to be starting the webinar. I'm Linda Colgan with Bryson Insurance and Associates Insurance Brokers, and with me today is Carole McAfee Wallace and Gordon Hearn from Fernandes Hearn. Our office puts on these webinars for the benefit not only of our clients but the industry. We have focused on personal lines, commercial, but our main flux of portfolio is in transportation. And one of the issues that we're constantly battling are contracts, shippers' contracts, brokers' contracts, the importance. People at Liberty just sign these contracts accepting terms that don't weave within the contract of insurance. They're two independent structures, and today we're hoping to provide some enlightenment with two very well-respected individuals in our industry. So Gordon Hearn, you can read about his bio here, and as well with Carole McAfee Wallace. However, I'd like to refer to both of them as two well-respected individuals who are so two very important references who with proven results. So I will turn this over to both of them, and thank you very much for coming. I appreciate everything. Thank you for coming up to the small town of Brooklyn, and we're looking forward to some insight into shipper contracts, broker contracts, terminology. There's a lot of transportation contracts out there that are accepting terms such as delay, any and all.
Yeah.
So I'm going to turn the tables over to you. So thank you.
Thank you. Thank you, Linda. It's good to be here in beautiful Brooklyn. So what do we mean by shipper contracts? Four different scenarios that we'll review today. There's the shipper carrier contracts, where you are the carrier performing the transportation of the goods. Shipper broker contracts, where you are actually brokering freight to another carrier. Then there's broker carrier contracts, where you're brokering freight to another carrier, and broker carrier contracts, where you're in fact the performing carrier. And we're going to discuss those various contracts in four sections. We're going to review some what we term aggressive terms in those contracts and what to watch out for with those terms. We'll touch upon how your individual business model and how you want to conduct your business and what terms and conditions are special and important to you. How are they applicable to these contracts? We'll review some liability considerations. And then lastly, we'll cover commercial considerations when you're reviewing or drafting these contracts. Trends and potential pitfalls, we'll get into the nitty-gritty of this in just a minute or so. But what we mean by that are a couple of big points. The lack of equilibrium when you're stuck in the middle as a broker. And that means, you know, you've got a shipper carrier contract, you're the carrier, you've agreed to certain terms and conditions. Now you turn around and broker that load, and what terms and conditions are you wanting to impose on the performing carrier? You're stuck in the middle. Are there other contracts between you and that performing carrier? You want to make sure that there's equilibrium or consistency and not conflict between the various parties to the bigger transaction, if you will. Again, signing whatever a shipper or an upstream broker presents to you. That's one of the danger spots to watch out for. And then being caught by certain special contract terms that are buried into a 10, 12 page dense contract. So we're going to talk about these pitfalls in more detail, covering those four categories.
So back in the old days, it was pretty simple. The regime tended to take care of itself. The so-called Uniform Bill of Lading enacted by the various provincial governments had it that there was this deemed $2 a pound limit of liability, for example, absent a declared valuation by the shipper on the bill of lading at origin. And the typical paper transaction, of course, was so limited. It used to be that the rate might be agreed upon over the phone or whatever, but the carrier would simply attend at the origin point, the driver issue a bill of lading, the shipper signed the bill of lading as the receipt to the carrier, And the bill of lading, coupled with the statutory terms, tended to fill in what the contract said. There was very little negotiation involved. Well, this, of course, has changed over time. Enter into the picture some sophisticated shippers who, over the last 10 years, have been increasingly coming up with these 10, 15, 20-page contracts. And they've been tendering those to the broker or maybe directly to the carrier to sign. And this is where we start to see some of these aggressive clauses. And we've got some examples on the slides here. And I also appreciate that the conventional rule with PowerPoint presentations is that you don't populate the slide too much. We've deliberately done that because in similar fashion, your upstream carrier or broker, or rather your upstream shipper or broker who's giving you a contract to sign, won't be breaking it down into one or two simple points for you. The salient points and risks you're incurring are going to be buried in language. And so we've got here some typical aggressive clauses to stay wise to. And the first big item is the cargo loss and damage claim. And the big issue here is particularly acute for those carriers involved in cross-border carriage. In the United States, you may be aware that there's the regime called the Carmack Amendment regime, which is their federal law on carrier cargo liability. And it deems or assumes carriers to be liable for full value. On the other hand, here in Canada, one of the basic principles that I alluded to earlier with those uniform statutory terms and conditions was the $2 a pound defense limit of liability. Even if you are liable, unless the shipper declared a value in the bill of lading, you can declare $2 a pound. Over time, some shippers and brokers who give loads to carriers have determined whether for the purposes of being uniform with the American regime or whether as a value add further protection for their shipper upstream, they've decided that let's start trying to impose full value liability on carriers. And where we need to be live to with the example language we have is a carrier shall be liable to broker and its customers for all loss, damage, or injury to cargo occurring while in the possession or under control of the carrier. And you read the last part of this paragraph. Any attempt by carrier to limit its liability or amend this agreement by provisions contained in any bill of lading, delivery, receipt, or tariff will be deemed null and void. So we need to be very deliberate about what the scope is of your cargo loss and damage exposure. Another example is the American type wording. When you see a similar clause defining the scope or the amount of your carrier liability for loss or damage to cargo, and you see a reference to the Carmack Amendment in language like we've got there, again, we're seeing the intent exhibited that you'd be liable for the full value. This has repercussions not only for you, but maybe your insurer as well. Does your insurance policy afford you coverage for just $2 a pound? The coverage grants back in the day tended to talk in terms of, we insure you for your liability for cargo loss or damage in accordance with the provisions in force in the province of origin type thing. But does it necessarily address full value? This is why you not only need to speak to your friends at Bryson from the get-go on what your coverage is, but you need to take a look at what the language is. What are you agreeing to? And are you trading away the ability to, God forbid you be liable for loss or damage, to at least limit liability? So the scope and the amount of your cargo loss and damage exposure is critical. So I mentioned the fact that particularly with respect to cross-border shipment, the disparity or the difference between American carriage law and Canadian carriage law takes on a really large focus. This is very, very important when you're doing cross-border work, and to identify what is it that you're signing on to, whether as a broker agreeing to be liable for cargo loss or damage, trying to pass it down, achieving what Carol alluded to earlier as equilibrium, that which you're assuming to your shipper customer, are you passing down to the performing carrier? Or if it's a direct shipper carrier contract with you and a shipper customer, what are you agreeing to? That's the first major thing to take a look at.
I'll now move into the second area of our focus. What's your business model, and what are your particular terms and conditions, and how might they apply vis-a-vis these shipper contracts? So we always start with the contract. If there's ever a dispute the first place you look is the actual written contract. And so you want to then consider whether there are any particular terms and conditions that you might have on your website, or some additional document that you rely on when you're dealing with shippers, or when you're brokering freight to another carrier. And are those terms and conditions incorporated by reference into that written contract? It can be possible to incorporate by reference additional terms and conditions, so long as that's done clearly. And beware of the entire agreement clause, because you don't want any contradiction. If this is the entire agreement clause, usually states that this particular contract is the entire contract, and that no other terms or conditions will apply. Again, the bill of lading, how does that fit in? And Gorgeous took you to a provision that was clear that there's full liability no matter what the bill of lading said. So be very careful and deliberate about how terms and conditions that are required in your particular business model are addressed in that contract. And then we've got what's called the Loadlinked conundrum that Gord's going to explain.
And before I talk about Loadlinked and the unique challenges it presents in this context, the language that you often find in one of these drawn out contracts, to Carol's point, is you may see something to the effect of the parties agree that to the extent that any terms in a bill of lading are inconsistent with the terms hereof, this contract will govern, and that the bill of lading will serve as a receipt only. It still has an important function as to how many pieces in their apparent order and condition that are received for carriage, but it will be ousted or demoted, so to speak, by the agreement. So the Loadlinked conundrum, and I call it a conundrum because there isn't really yet a perfect answer, but here's the scenario. We're here this morning telling you about the importance, particularly if you're in the brokerage middleman, middle person context, of trying to have equilibrium or passing down what liability you might be taking onto your shipper to the downstream performing carrier you're engaging. In a perfect world, you would have a 10-page contract maybe insisted upon by your shipper, and you would have a back-to-back mirror agreement with your carrier. But what if you don't have a dedicated stable of carriers in your brokering function here? Or what if you want to broker it out or assign to somebody who's posting their assets on Loadlinked? Because sometimes, as we know, Loadlinked can fill that gap that a dedicated carrier arrangement can't. Now, all of a sudden, you have a stranger who's a carrier coming to the party. At most, there might be a quote over the phone, some exchange by emails, and a carrier or rate confirmation sheet exchanged with the carrier. Where has that carrier come to terms with what you would like it to sign relative to what you've assumed with your upstream shipper? This is a challenge, and it calls for management being deliberate on what loads are you brokering out or going to the link for. Lately, I've had some carriers tell me that they're able to post in a comment section on Loadlinked, wording to the effect that, or brokers rather, posting wording to the effect that whenever a carrier accepts a load, they agree to be bound by the terms on our website. Go to www.broker.com. But then that takes us back to Carol's point about, is that an effective incorporation of those terms? The jury's out on that, but it's a bit of a tricky area. Declarations of value. The other area that we need to be concerned with, and this isn't so much contract terms as much as what is your practice as a carrier. I've never really understood in my 30 years in this business about how the ceremony is really supposed to work, with the shipper declaring a value on a bill of lading while the motor is running at the point of pickup. I mean, let's unpack that a little bit. So maybe you've negotiated as the carrier a rate assuming $2 a pound general liability. The carrier confirmation sheet's been issued, you dispatch your driver and your equipment, and the motor's running, the load's being put onto the conveyance, and wait a minute, if the driver even notices, the shipper's declared a value on the bill of lading. What does your driver do? In our experience, maybe yours, drivers ignore it. Maybe they don't read the bill of lading. But do they call dispatch? What does dispatch do with that information? Does dispatch then go down the hallway to speak to the insurance person? Are we going to surcharge this, you might ask? What do you do? That's an unfinished equation. And so there's two dangerous little issues that come with the bill of lading at the point of origin. And I ask this rhetorically because there's no answer. Number one, what do you do and what is your driver instructed to do when there's a declared value? Number two, some carriers in our experience come to rely on their form of bill of lading, which may have wording to the effect of, unless we've agreed beforehand and specifically negotiated a freight rate, regardless of what happens at the point of loading, your liability is limited to $2 a pound. But what happens if the shipper says, I'm not signing your bill of lading form, Mr. Carrier. We're using my form of shipping order or bill of lading. And again, no perfect answer, but things to be alive to.
Another consideration is, are you brokering loads? And if so, are you able to broker loads? What does your per carrier contract say, for example? And we've included a provision that we see often, that the carrier shall not rebroker a load without the shipper's written consent, although it happens all the time. So one of the consequences is look at the contract and see what the consequence of that kind of breach. It could be you lose your right to seek payment of the load. But more importantly is that the danger is that you're at risk of losing an independence or an independent contractor relationship with that carrier. So we've included two clauses that we see. The first one we've identified as an ugly clause, and that's the one where you, in the role wearing the broker hat, warrant and represent that the drivers are compliant and fully trained, and that the equipment is roadworthy. That you are making that rep and warranty, and in a casualty type of context where there's a tort claim, then you, the carrier, have basically assumed exposure. The contracts that you enter into and that will govern the transport will be a document that will come out in any kind of litigation. It's a document that is to be disclosed in an examination for discovery, and that first clause that we've described as the ugly clause will be very risky and will attract liability to you for making that rep and warranty. A better, although not perfect, alternative is that you warrant and represent that you will hire carriers who will agree in writing that they have drivers who are compliant with the law, who are fully trained, and use equipment that's roadworthy. And again, if that's what you've warranted and represented, then you better make sure that you do have that backup written confirmation from the carrier that you've hired. There's, and Gord can jump in because he's got more experience in this area, the negligent hiring of a carrier by a broker is a very big issue south of the border. And as what we see up here in Canada is where issues develop and class actions are brought and laws are developed south of the border, it's only a matter of time before they're imported up here and people are making the same kinds of claims up here. So the sub-brokering is risky, both in terms of being a potential breach of your contract where it's forbidden, but even more risky is the fact that you'll lose that independence with that performing carrier and that you'd be exposed.
Yeah, I mean, indeed, in terms of liability, there are two buckets or two sides of the page to really simplify everything here. Part one, which we're speaking about mostly, is cargo liability for loss or damage. That's out of the four corners of the contract that we're talking about with your shipper or with an upstream broker if a broker is engaging you as a carrier. But as Carol says, there's this other very sinister, more remote or rare scenario of the casualty claim, where if your rig or if the trucker gets involved in an accident on I-75 or the 401, and then there's ensuing personal injury or estate litigation, that party in the station wagon that's been injured or worse in the accident they're not bound by the four corners of a contract. They have a claim in tort or negligence law. And as Carole says, the danger is that when you define your involvement using words as a broker, as though you control the actual drivers or monitor the equipment, you're crossing that very, very delicate balance of your carrier no longer being an independent contractor for whom you as the assigning party are generally not responsible in law, to now making it look like you undertook an obligation to train the drivers. Where we see these two clauses often come up is in the context where a shipper maybe thinks it's hiring a carrier, or it goes to a broker and says, you're going to do this work for us. If the broker is on the up and up, they're going to disclose, of course, to the shipper that they don't have assets. It doesn't want to get into default from the get-go and making the carrier think that it's the performing party when it isn't. But the problem we see with the first item up top is that usually it would say carrier warrants, and there's a whole bunch of reps and warranties you've no doubt seen in contracts like this. Well, that's displaced, of course, as Carole said, when the broker says, we represent and warrant. So the item at the bottom is sort of a half-cocked response to that that sometimes, itches the scratch, where you as the broker will say, okay, we'll do one thing a bit removed. We're not going to rep and warrant, but we're going to make sure the carrier we engage signs this. But the problem is, what if the broker has a dedicated stable of carriers who are already mid-term? You can't hurry up and renegotiate those contracts. Or the other problem is, remember that Loadlinked conundrum I talked about. If you're going to go to the link, how are you going to get your carrier to agree on these terms that you as the broker have represented and warranted to your upstream shipper that you were going to do? Very difficult dynamics.
Now, we did have one question. I'm sure that James's answer lies within the context of the past couple slides, but he did have a question that says, what happens if the driver does nothing? What's the risk? And I do believe it's been answered.
In terms of issuing a bill of lading?
Yes. So if he gets to the site, there's a declared value and he doesn't notify dispatch, doesn't alert anyone, just takes it. It's now for, let's say it's $500,000, James. Cargo limits are $200,000. You're self-insuring $300,000 right away. So
that's a nasty scenario, and we're dealing with a couple live ones right now like that. The harsh, conventional, or old answer to that would be a declared value is a declared value is a declared value, meaning that if the bill of lading has a declared value, the simple answer, up until maybe the present, would always be, in my opinion, you're cooked. Where it gets a little murky, and I'll keep this brief because it's sort of off grid a bit, but for whatever reason, 10 years ago, the Ontario government changed the language of our uniform bill of lading to say that the contract of carriage must have a declared value. Whereas the legislation used to say the bill of lading, and the other provinces in Canada still talk about the bill of lading. There's an interesting argument that might be made that if the parties beforehand have either with a fancy contract reduced the bill of lading to being a receipt only, then they've dealt with that. But maybe they don't have that fancy contract. I've got one scenario right now where there was a specific negotiation of a direct line haul freight rate, no discussion about a declared value, and the circumstances add up to suggest that the shipper was pulling a fast one at the very last minute. A hurry up sort of gotcha bait and switch moment. Oh, wait a minute, I'm going to write a declared value on the bill of lading. We're left trying to argue that the contract of carriage was more than the bill of lading. It includes the freight rate negotiation beforehand, the earlier emails, etc. But that's a dangerous position to be in, and there's no case precedent answering it definitively one way or another. So the short answer is the driver should pay attention, and when in doubt, call dispatch.
Educate, educate, educate,
Yeah.
So, okay, carry on with the liability considerations, our force majeure.
Thank you. So force majeure is a term that's in most contracts. But what does it really mean? And it's a term that allows a party or either party to be relieved from performing under the contract for certain reasons. And what's key is that it's again freedom of contract. The parties can negotiate what the issues would be or what the events would be that would relieve a party from performing, and how long would the party be relieved from performing. In the sample that we've put up on the screen, it's for the period of the delay caused by the event, and in this case, they've listed failure of power, government act, labor strikes, that kind of event. And then the other, and so long, and what's key is that these events are not the fault of or under the control of either party. So these are things that are beyond a contracting party's control. And one of the other key clauses in a force majeure term would be that prompt notice be provided if a party is going to rely on this clause to relieve it from performance.
And this is an important clause because, as Carol says, it relieves either party from overall performance. But this points out to me an important consideration that was sort of buried in one of the earlier slides. Remember, I mentioned the fact that you want to be careful about what that cargo loss and liability clause looks like in terms of full value versus $2 a pound. It's also important that you remember that as a carrier, you're not automatically liable. You're not going to be liable every time there's loss or damage between A and B. There might be an act of God. There might be shipper's negligence. The classic silly example is the shipper shipping a chandelier in a box with no dunnage or securement in the box. That's not ordinarily going to be able to withstand the usual rigors of transit. With the proper expert proof at trial, the carrier is not liable for that. But those are common law defenses generally reserved, and they're codified or reserved in the Uniform Bill of Lading. But we see some very aggressive shipper contracts which oust those defenses, arguably in its extreme, and it remains to see what a judge will do with it. But some clauses sort of read like you're immediately liable the minute there's any cargo loss or damage, and you need to stay alive to the fact that you're entitled to some defenses. So I mentioned this concept of casualty litigation. So in the worst type scenario, there's an accident involving maybe your rig, or it might even be your dispatch carrier's rig if you brokered it out. And there's an accident, and we see a lot of precedent in the United States with this. Hasn't yet happened in Canada, but it's a matter of time, where the plaintiff or their lawyer goes up the supply chain looking for deep pockets. They'll certainly sue the performing carrier, but maybe that carrier is insufficient insurance, or maybe the amount being claimed is so catastrophic or large that the insurance isn't enough, or maybe the insured carrier has gone off cover or compromised their coverage. You could find a claim being advanced against the broker, you in that case as a broker, or even in extreme cases, the shipper, because some ingenious plaintiff's lawyer is going to ask, and let's think about project cargo. There's a flatbed with special rigging requirements or whatever. And now all of a sudden there's a question about who controlled the placement of the cargo and who ought to have instructed whom about how to lash or secure the cargo. The shipper could be sued. The broker could be sued. And what we see increasingly is shippers saying to the broker, we want you to hold our hand if we're ever sued. If your carrier gets into any trouble, you, the broker, will hire a lawyer for us at your cost, and you're going to pay any damage award that we might get hit with. Or this might be placed on the carrier, where the carrier has to protect the broker and the shipper upstream. This is very, very dangerous, this language. And at a minimum, there needs to be reciprocal language where, especially in the context of rigged cargo, or where the shipper has some role to play in the lashing and securement and placement, that the shipper should be giving an indemnity to you, the carrier, or to you as the broker for its sins for which it's shown to be responsible.
Now we do have another question here, Gordon, from Mel.
Yeah.
And it's a bit too far out of my reach to see. So, Carol, can you?
The question is changes under the CMA that may impact contracts today or in the near future.
Great question. I'm not aware of that. And I suppose the simple, lazy answer to that is with the Democrats, we don't even know what's going to happen with the USMCA. But I haven't yet to drill down into whether or not there's going to be any effect on that. I'm going to say no, and here's why. Because NAFTA, as it was, didn't regulate or have anything to do with the cross-border contracts of carriage. There were attempts a while back to come with a continent-wide uniform bill of lading for both countries. That went by the wayside. I'm unaware of, or I haven't heard of USMCA extending the regulatory regime or purview over private contracts like this. So the short answer right now is no. Over you, Carol.
Continuing on with liability considerations, and we've touched upon this earlier when Linda gave the example of the amount of the insurance coverage is a lot less than the amount of the loss, and then you're exposed to being self-insured. So the next two screens are examples of the type of insurance that we see in contracts that are parties required to get. So here are the list of the types and the amounts of coverage that the contract is requiring. And then on the next screen, these provisions are also common in these contracts, adding the shipper as an additional insured or naming the shipper as a loss payer for cargo liability. You got to stop, take a look at those clauses and talk to Bryson. Is it even possible to obtain that coverage? Do you have that coverage? Can you get that coverage? And can you comply with the types of provisions that the insurer is requiring in the contract? Again, basic contract rules. It's freedom of contract. Parties are open to agree to the terms and conditions that govern their relationship. They set it out in writing. You've got two sophisticated parties signing a contract, and once you sign it, it's a binding and enforceable agreement. So it's very important to ensure that you know what you're agreeing to or being asked to agree to, and check with Bryson to make sure that you can in fact comply with those requirements.
And it's no false modesty on our part when I can tell you that this is the part of the contract that there are two parts of the contract when we're asked to review that we're not comfortable commenting on. One is the metrics, the appendices with pricing and rates and lanes and all that. That's the business side, which lawyers shouldn't be interfering with too much. But the other part is the insurance bit. We're not insurance brokers. We don't know what products are available. And we see a lot of discussion about everybody up the supply chain wanting this additional insured protection. But is that even possible, as Carol says? So that's an important thing to get. Most contracts, in my experience, are fair in that what shippers are handing the carriers or brokers handing the carriers has this clause, but this is critical. It's important that you protect yourself from consequential damages. Cargo loss and damage is one thing for the actual value of the article itself. But with the example of show freight, as I've listed, or contract tenders, you want to avoid any suggestion that you're liable for the consequences of a late delay or delivery of something. So a show booth might be worth $100 going to a trade show. But if it's lost or damaged or delayed and you miss the trade show, what if the shipper or consignee says, had it been there, I would have earned $1 million in business? The case law has dealt with this in a fairly helpful way, whereby unless you as the carrier are put on specific notice that there's bad things that are going to happen if you don't perform the contract a certain way, you're not going to be held liable for those unforeseen things. But where it gets a little murky is with the bill of lading says trade show and must deliver by Monday morning 9 a.m. to set up and things like that. It gets a little dangerous. And the way to protect yourself is to say we're not liable in any event for any consequential damages. So that's an important item. Deemed loss clauses. We're seeing this more and more in the United States right now. This is a general nasty scenario, and it's been made even more complicated with the so-called final rule concerning perishable goods and foods in the United States, which I'll get to in a moment. But what we see some clauses, and you may see this as well, but language to the effect of if the seal is broken by anybody other than a designated representative at destination, the carrier agrees that the shipment will be deemed to be lost. And it gets even more aggressive. You have no rights of salvage. This all came with the Tylenol scare 25 years ago, when certain pharmaceuticals went out of the chain of custody for a while, and there was concern about whether they might have been tainted and put back into the supply chain. But since then, for quality control purposes or whatever, many shippers, particularly the large ones, the pharmaceuticals and the like, will have it that if there's been any taint or suggestion of taint, it's a deemed loss. And with freedom of contract, as Carol said, you'll be held to the written word you've agreed to. If you're going to agree that if anything is untoward in a certain way, that not only is it a full loss, but that it's no salvage right for you to even take the goods back to try to make lemonade out of lemons, that's a real double whammy. The other thing that we want to be careful about is avoiding that you're agreeing to be liable for retail cost as well. So that goes back to the discussion we had on valuations. So that's a sample of the clause that I was just referring to, but in the event that a seal is broken, we want to be very careful about that. So now we come into recent days, what we call crush and dump scenarios in the United States. In 1995, the US Congress passed legislation, the Federal Food, Drug, and Cosmetics Act, which said that anything meant to be consumed or used by a human being, if reasonably suspecting of having been adulterated in transit, is supposed to be rejected by the receiver, the consignee. This is a clash right now that the struggle is yet resolved with conventional US and, for that matter, Canadian carriage law. In the States and Canada, even though we have different rules that we talked about limiting liability, the rules are generally the same. You as a carrier are only liable for actual loss or damage established by the claimant, not pretend loss or damage or assumed or worried about loss or damage, but proof of loss or damage. So on the one hand, you now have consignees rejecting foodstuff loads because a seal might be broken, or one skid, the shrink wrap might be interrupted on a skid or something. There's some fear that it's been adulterated or tampered, and they reject the whole load. The carrier defends that claim, saying, you have to prove through a laboratory analysis or otherwise that the food's been tainted. And that has not yet been resolved. In the States, we now have the sanitary transportation of human and animal food rule. In Canada, on January 15th next year, we have our Safe Food for Canadians regime coming into effect, imposing further obligations on receivers of goods. So it's a bit of a mess right now. One possible answer comes with recent commentary from the US FDA, where they've basically said that the adulteration rule does not apply to concerns about depreciation of market value or appearance. So if somehow it can be established that goods have to be repackaged, maybe we have tinned or canned food or packages within a larger crate. If the outer packaging's been disturbed without much more, that appears to, according to the US authorities, not be a basis to reject the load. But this is a big problem. So that's why I said the FDA has dealt with those carriers' worst fears in that regard.
And the last point we want to make in the liability considerations refers to the governing law and venue clauses that you find in these contracts. And we see this all the time where we've got two examples there. The first one is a jurisdiction that requires any action to enforce any provision of the contract has to be brought in Florida, and that the carrier consents to exclusive jurisdiction and the venue of such courts. The use of the word exclusive means that the court will uphold that and give the Florida courts exclusive jurisdiction. Therefore, if you've got a dispute over payment of freight charges even, you're bound to go to the courts of Florida. The second provision we've put on the screen is that the provisions of the contract shall be construed and enforced according to the laws of, in this case, the state of Delaware. So again, the parties are agreeing that if there's any dispute, the law of a certain jurisdiction will apply. Again, courts will enforce these governing law and venue provisions. So it's important to turn your mind to whether this is something that is that you're prepared to agree to, because the inconvenience of having to go to another jurisdiction to enforce your rights under a contract is one consideration. But to the points we've been making earlier this morning, you've got some liability concerns. If the governing law is a US law, then you're under Carmack law, full liability, versus Canadian Ontario limited liability, $2 a pound. So you have to be careful that you're not agreeing to be governed by a body of law that exposes you to greater liability than if you were able to ensure that the law of, for example, Ontario was the governing law.
And to draw earlier comments to a circle, you might decide that you want to assume these things as a value add. Maybe as a broker, you're prepared to assume contracting liability, but in the hope that you're either insured for that risk, or ideally, perhaps you can pass it down to the carrier. So there's sort of an equal and opposite feature here. In a way, some of the things we're telling you to be careful about are things that you might want to be negotiating to pass down to a carrier if you're brokering it down to the carrier. It's all about identifying the risk and being deliberate about it.
And so that works nicely into our fourth topic. What kinds of terms and commercial considerations should you turn your mind to when entering into these contracts, negotiating them, trying to revise them? Under the Ontario Highway Traffic Act, there is a provision that requires anybody who arranges with an operator to carry the goods of another for compensation to hold that money in trust for the carrier. So brokers are clearly obligated to set up a trust account and hold monies that they collect for the carriers. But a carrier who would broker a load is also bound by this term. So it's important to be aware of that obligation. We do see the provision set out on the screen where a carrier waives the requirement for a trust fund. Beware of that. It remains to be seen whether it is legal to waive that trust requirement. We've got sort of an argument going on in our office sometimes about whether that term is in fact enforceable. But given that the law is not settled on that, beware that you're not signing something where you give up the right to ensure that those monies that the broker collects on your behalf are maintained in a trust account.
One question we had posed is, it goes back to the earlier slide, Carol, but whether we can pass it all down, that's the risk, to the carrier, or am I still liable? I'll take a first stab at that. It depends on what the business model is. If you are brokering out a load, whether as a full-time deliberate brokerage division or just incidentally as a carrier where you can't perform the load but you pass it on, the short answer is that if you are involved as a broker, you might just set it up as though you're an agent only. You're a travel agent for the cargo. This is what brokers and freight forwarders used to be back in the day, before they started having shippers impose upon them requirements of actually assuming liability. And many brokers choose to do that as a competitive value add. But I think scenario number one is, if you're a broker agent only, you're not issuing a bill of lading, or you're not making it look as though you're responsible either by an agreed contract like this or acting as though you're responsible. One of the classic ways of looking like you're a carrier is if the broker's name appears on the bill of lading at origin. They're endorsed on it. It starts to look like you're a carrier. This is assessed all through the lens of what the shipper reasonably understands. So scenario number one is you're not liable, and you can pass all of these risks that we're talking to down to the carrier if you have structured it accordingly. With the one exception that in the United States, there is a vetting function. There's an expectation that brokers be reasonable in how they identify and instruct carriers. Identity theft is a classic example that we hear about these days, with rogue third-party carriers showing up at origin to pick up cargo. If the argument is that the broker, even though an agent only, was reckless in how they handled the paperwork, or they didn't properly vet the carrier, there might be liability there. The second scenario is that if you're a contracting broker, then the answer is yes, you are liable, but then you can flow it through to the carrier. And in a practical dynamic, that means that if there's a cargo claim and the shipper has sued the broker, you, and the carrier, or maybe you bring the carrier in, at the end of the day around the settlement table, in a perfect world, it's the carrier who is paying. But again, we come back to that cardinal concern from the outset. What if you as the broker have agreed to full value liability with your shipper? But what if your carrier has agreed or says it agreed only to $2 a pound? You could be left underwriting that difference. So that's the equilibrium bit that Carol was mentioning at the beginning. So another commercial consideration that we sometimes see is the carrier trading away a right that you have at law. And this concerns unpaid freight bills. Maybe the shipper, or for that matter, your upstream broker, has defaulted and they're not paying you your freight bill. As you may be aware, under federal law, if two conditions are satisfied, you have the ability to go after the consignee receiver. And this is a very effective remedy because certainly in cases where there's a shipper and then there are intermediary brokers by the time that you're involved as the performing carrier, that default may have happened in some of the upstream brokers. But the initial shipper customer will be less than pleased to realize that its customer, the buyer of the goods, being the consignee, is being approached for payment. So this is an important potential remedy to be alive to. Where the consignee receiving the goods is named in the bill of lading, and where it is taking ownership in the goods, then you as the carrier can approach that consignee for payment. Now there are a couple of exceptions I won't get into here, but here's the potential problem. In many shipper-imposed contracts, you see language to the effect of the parties agree that broker is the sole party responsible for payment of carrier's charges. And the case law on point has held that a carrier might waive its ability to rely on the Bill of Lading Act I just took us to if there is such a clause. So you need to be careful about reserving your rights about claiming against consignees or third parties for unpaid freight bills.
Another provision that we see in these contracts is the carrier waiving the right to the carrier lien. So the carrier lien being able to maintain possession of cargo until payment of the freight relating to that cargo is received. So beware of not only waiving that right to a lien, but if the carrier tries to assert that lien, the provisions add a further right on the shipper's part to seek an injunction. So that's drag a carrier into a court proceeding and to pursue the carrier for damages that might flow from this breach of the provision in which the carrier waived the right to the carrier's lien. Another very common provision that we see in these contracts is giving the broker the right to offset any payments owed to the carrier for liability due to freight loss, damage, or delay. And those result in many lawsuits where the amount of damage might be a smaller amount, and then the broker just withholds all of the freight fees that are owed to the carrier, and the courts again will uphold these provisions and allow the broker to do just that.
And we're on to the last slide here, and it's something that we're starting to see litigated at the trial level right now, and it's the no back solicitation clause. You see standard clauses like this in all the broker industry forms. The National Transportation Brokers Association standard broker carrier contract in Canada has this. The Transportation Intermediaries Association contract in the States has this provision. The jury is out about whether this is enforceable according to its strict terms. There are tough proof elements here. You know, I mean, might you as the carrier been performing movements for this shipper before the broker got you involved? But brokers are naturally concerned about becoming redundant. That's why for years they've insisted on separate invoicing between the carrier relative to how it then invoices the shipper. And they want to preserve the business. Our courts do allow, in certain cases, the parties to in advance predict what the damages might be. We call it a liquidated damages clause. The court will only enforce the formula we see in the second paragraph. In cases where the facts suggest that it was a genuine pre-estimate of losses. So you can't enter into a contract with somebody and say, if you breach this contract, I get your firstborn and $1 million. I mean, yes, we said earlier that contracts tend to be enforced with freedom of contract according to the written word, but there are some limits. And one of the limits are when parties in effect try to do the court's job for it in predicting what the damages are arising from a breach, the courts will give effect to it. It's seen to be a reasonable pre-estimate of damages. So that was the summary of what we thought were the big takeaways on the insurance and the casualty bit. 3 actionable items to take away. Carol, what do you think? We got 3 items ready here.
Are you gonna kick off, or do you want
No,
me to?
you
Okay.
can kick off.
So here's what we think, and then Linda would like to hear what you might add. So first of all, be deliberate with your business model. That's been one of the themes in our discussion this morning. Where are you? Are you the carrier? Are you the broker? And where do you fit with the other parties to the transaction? Be very deliberate with how you word the contracts, or which contracts you agree to. And then last, you got to speak to Bryson before you sign anything.
Thank you. Thank you very much. Well, we'll have a little bit of Q&A here as well. So if you have any questions, please post them. But 3 actionable items, very, very easy. You know, as I've said, you know, carriers have limited defenses. Don't waive them.
Yeah.
You know, you have to respect that there's an insurance contract, and a shipper or broker's contract is much different. The language does not speak to each other. They are not pillars for each other. They can actually work against. So, and a contract of insurance does not necessarily weave with any contract for a shipper or a broker. I've always said one of the things with transportation, you are the professional. You are the ones that know how to rack, stack, pack, take, and go over the border, deliver. Then why would you take on the responsibility of a legal contract? Fernandes Hearn deals with not only the transportation, international freight, you know, all contracts should be referred to a lawyer before you accept the responsibility. So you have the professionals here, as I've said before, you know, they're references with results. And, you know, as you can see today, there's not just one answer to anything. It deals with law, different territories, geographical, you know, arenas and jurisdictions. So, you know, my takeaway is definitely, you know, when you review them, don't assume the responsibility yourself. Refer it to your legal team, which I hope is Fernandes Hearn, because you definitely are well respected in the industry and definitely have earned my respect.
We have another question.
We have Tad here.
Yeah, do any observations from the recent developments involving the Driver Inc. business model that carriers should be aware of and conversant in? Well, that's fascinating. In a quick second, I'll turn it over to Carol, who's our labor and employment specialist. But point number 1 I'll register is I believe CRA has recently weighed in that they're going to be pretty aggressive in analyzing whether Driver Inc. or the individual incorporation of a services company is going to be accepted and tolerated. But in our context, Carol, correct me, but where I think this comes in is you may all have heard of the classification litigation going on in the United States, in particular California. FedEx, Uber, all the big companies have really been struggling with how to deal with the owner-operator model. And might somebody come along and say that the owner-operator is really an employee? with all the ugly class action stuff that can happen with that. And one of the models that they've been pursuing in the United States is a broker model where you as the carrier, instead of hiring, I sort of need a blackboard to go through this, but you as the carrier, instead of hiring owner operators, in effect set up as a broker, and that you in effect hire individual driving companies rather than owner operators, and those individual corporations will be carriers in their own right who will perform the move as though the loads have been brokered to them. That might solve that itch, but that conflicts with the recent attack on Driver Inc. here in Canada. I asked one of our colleagues about this the other day, and he thought that the answer would be to insist as a carrier that the owner operator or the Driver Inc. be companies comprised of at least 3 employees or more to get off of the CRA attack on that. Can you add to that, Carol?
I think that's right. I think what has been described as Driver Inc. and one person incorporating, not owning their own equipment and driving for the company, leaving aside the tax consequences that Driver Inc. model is facing, leaving aside the fact that if they are a driver service, they may be obligated to charge HST and nobody's charging and collecting it. The other sort of bigger risk is that they could be determined to be employees, and then you've got liability for termination pay, overtime, vacation pay. Right now I'm seeing only individual disputes brought to the courts, but it's only a matter of time before we might see a class action.
Another good question is, how long does it take to review a contract, and do we find that contracts are negotiated, or they mostly take it or leave it? Reviewing a contract, it could be an hour or less for we as a lawyer to look at it, to red flag things like what we've done here. Where it gets more expensive is in the wordsmithing. In other words, where it comes to actually drafting new terms or trying to harmonize or get equilibrium between an upstream or a downstream contract and take more work. That could be 5 or 6 hours easily. Good question about whether contracts could be negotiated. Historically, I'd say they tended to be take it or leave it, but I think our audience is in a better position to answer in terms of driver shortage, carrier capacity, where carriers finally have a bit more leverage than used to be the case. The conventional wisdom is poop rolls downhill. The shipper can impose the world on a broker who can impose the world on a carrier. Now I think the carriers, you may have finally some legitimate leverage. We're seeing some acceptance, particularly in extreme examples. As I say, where you're a broker and the shipper's given you what's clearly a shipper carrier contract, they should not expect you to sign something that right out of the get-go is not right, where you're warranting that your drivers do this, or not allowing you to broker out to a third party when you're going to have to do that. So we're seeing some elements of negotiation, but it's the immediate dynamics that will govern that.
And as I've always said as well with contracts, you receive a contract, you look at it, you have 3 options. Number 1 is you can review it, with a legal team. You're not the professional in that arena, or else you'd be a lawyer. You're a trucking company or you're a load broker, so you shouldn't take on that responsibility. However, if you do, you have the opportunity to vet the wording and either push back, saying, we are not going to accept these terms, try to negotiate something that might be a little bit more plausible for both sides. Or you can accept the responsibility, but you are aware of the disconnect between insurance and what you're self-insuring. Then, there's constant verbiage on how, if we don't take the contract, we won't make any money. However, there's a scary scenario. There's a total void of coverage. So you're taking on the responsibility where your insurance is dropping off. Or the third option is just not to take the contract. So there's 3 options there. We also have a comment here from Tracy as well. Exceptional. Thank you, Tracy. The information shared is extremely valuable. And so well articulated. Thank you very much.
Thank you,
This is
Tracy.
over.
Does Tracy get a prize for being nice?
I think so. She gets to look at us for another couple minutes. Now we have a comment here from Tat.
Yeah.
Thank you to Carol, Gord, and Linda, the best professionals you have on your side. Thank you very much, Tat. Greatly appreciated. We need to share that gift between Tracy and Tat. Yeah. So thank you very much. We will wrap up. I would like to say, if you have any further questions, you know, we will definitely be in, you know, you can reach out to all of us. However, I would say that definitely reach out to Carol and Gordon. What a great team. Thank you. We're truly honored that you came to make a difference in the transportation sector. So thank you very, very much.
Thank you.
Thank
Have
you,
a good day,
everyone.
everyone.